Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. On April 23rd, the Federal Trade Commission issued a final rule to promote competition by banning non-compete agreements nationwide. They claim this is in order to protect the fundamental freedoms of workers to change jobs, increase innovation, and foster new business formation. Here's what they said about that. Non-compete clauses keep wages low, suppress new ideas, and rob the American economy of dynamism, including from the more than 8,500 new startups that would be created a year once non-competes are banned. That was from FTC Chair Lena M. Khan. The FTC's final rule to ban non-competes ensures that Americans will have the freedom to pursue a new job, start a new business, or bring a new idea to market. Now, the FTC estimates that the final rule banning non-competes will lead to new business formation growing by 2.7% per year, resulting in more than 8,500 additional new businesses created each year. The final rule is expected to result in higher earnings for workers, with estimated earnings increasing for the average worker by an additional $524 per year. And it's expected to lower healthcare costs by up to $194 billion too over the next decade. In addition, the final rule is expected to help drive innovation. Now, non-competes, as I've said on here before, are widespread, and they are sometimes exploitative because they impose contractual conditions that prevent workers from taking a new job or starting a new business. Normally what happens is somebody comes to work and they say, we're going to share our way of working with you. It's proprietary to us and we don't want it shared with other people. And we also don't want you learning from us and then 6 months from now you go off and start your own business that copies our model. So we're going to make you sign this contract that says that you can't work in this type of job anywhere in our area for 2 years after you leave employment. Well, that has an effect on an individual. One, they don't want to change jobs now because they know they can't work in the town where they live in that particular job. So I've seen this happen particularly to doctors. Doctors will be recruited to come to a new town, come to Auburn, come to work for us at Our Lady of Perpetual Billing Hospital, and they go to work for Our Lady of Perpetual Billing, and they don't get the raise that they were supposed to get the first year, and job growth is sort of limited because the people who are there have been there for 15 years, and as a result of that, they would really like to change jobs and maybe go work as a doctor in an urgent care clinic, but now because they have this non-compete agreement, if they do that, they're going to get sued. The problem for the person who is bound by this non-compete agreement is if they decide to violate that contract, they may be subject to a liquidated damages clause that makes them pay, a certain amount of money, or perhaps even enjoins them. The court goes and issues an order enjoining them from working in the local area. So these can be quite significant, and I'm not a big fan. I think they're a bad idea. According to the FTC, an estimated 30 million workers in the United States are subject to a non-compete agreement. That's 1 in 5 Americans. Under the FTC's new rule, existing non-competes for the vast majority of workers will no longer be enforceable after the rule's effective date, around August of this year. Employers will be required to provide notice to workers other than senior executives who are bound by an existing non-compete that they will not be enforcing any non-competes against them. In January of 2023, the FTC issued a proposed rule, which was the subject to a 90-day public comment period. The FTC received more than 26,000 comments on the rule, and over 25,000 of them were in support of the rule. The comments informed the FTC's final rulemaking process, and the FTC carefully reviewed the comments before they made changes. In the final rule, the Commission has determined that it's an unfair method of competition and therefore a violation of Section 5 of the Federal Trade Commission Act for employers to enter into non-competes with workers and to enforce certain non-competes. So that's the That's the upshot of the rule. But since the notice of rulemaking last year, it's been fairly clear that the rule is going to be challenged in court. Now, the FTC relied on its authority under Section 5 of the Federal Trade Commission Act, and that declares certain methods of competition to be unfair and unlawful, and it authorizes the Commission to make rules. In voting against the final rule, two commissioners, Melissa Holyoke and Andrew Ferguson, echoed the lengthy opposition of the former commissioner, Christine Wilson, claiming that the FTC lacks the authority to engage in rulemaking of substantive competition rules. Now, they can regulate procedural rules, but they can't regulate substantive competition rules. That's their position. Whether or not the courts adopt it is another one. And they also say the rule is barred by the Major Questions Doctrine, and it's an impermissible delegation of legislative authority under the non-delegation doctrine. And the non-delegation doctrine essentially says that Congress may not delegate substantive lawmaking authority to an agency because that's what Congress is for. So it can write rules that interpret the law that is passed by Congress, but it can't make new law or make law that is inconsistent with the statutory language. So several of the commissioners have taken the position that the plain text of the statute expressly gives the Federal Trade Commission authority to make these rules. But people who criticize the rule have emphasized that more recent decisions trend away from the authority that the Commission has expressed here. Now, the biggest stumbling block, in my opinion, to the FTC rule is called the Major Questions Doctrine. And the Major Questions Doctrine is a principle that addresses the question of whether an administrative agency has the authority to interpret or implement a statute that involves significant or major questions of public policy. The doctrine typically arises in cases where there's an ambiguity or a silence in the statutory language regarding whether the Congress intended for the agency to have that authority. Under the doctrine, courts may be hesitant to defer to an agency's interpretation or implementation of a statute if the issue at hand is considered a major or significant question of public policy. Instead, courts may say, we need to really look at this and make sure that there is a clear expression of congressional intent or involvement. Now, the doctrine often intersects with principles of separation of powers and the non-delegation doctrine, and those dictate the extent to which Congress can delegate its legislative authority to administrative agencies. And of course, that's because an administrative agency is an executive branch agency, and Congress, of course, is the legislative branch. So you can see where you'd have separation of powers issues. Critics of broad agency discretion argue that allowing agencies to decide major policy questions essentially without guidance from Congress leads to an improper expansion of executive power, and it undermines democratic accountability because the people making these changes and making these rules are not elected. The people who appoint them are elected, but they themselves are not elected, and they can't be removed by the president. Now, the Sentinel case is West Virginia versus the APA, which is a 2022 Supreme Court opinion. Now, West Virginia versus the EPA was a long-running case in the federal courts about the agency's, EPA's, Clean Power Plan and how it was supposed to be implemented. And there were numerous objections to it, and among other things, there was an objection raised under this Major Questions Doctrine. And here's what the Supreme Court says. Precedent teaches that there are extraordinary cases in which history and the breadth of the authority of the agency has been asserted, and the economic and political significance of that assertion provide a reason to hesitate before concluding that Congress meant to confer such authority. And of course, they give the FDA versus Brown and Williamson and some of these other cases as examples. Under this body of law, known as the Major Questions Doctrine, given both separation of powers principles and practical understandings of legislative intent, the agency must point to clear congressional authorization for the authority it claims. Now, the EPA in that case claimed to discover an an unheralded power representing a transformative expansion of its regulatory authority in the vague language of the long extant but rarely used statute designed as a gap filler. That discovery allowed it to adopt a regulatory program that Congress had conspicuously declined to enact itself. Given these circumstances, there is every reason to hesitate before concluding that Congress meant to confer on the EPA the authority it claims under Section 111D. How does that translate to the Major Questions Doctrine and the FTC in this case? Well, non-competes have been around for a long, long time, probably the last 70 years, although they have become more prevalent in recent times. But the fact that there have been non-competes and Congress has never legislated on that, and they've never declared it to violate the Antitrust Act, they've never declared it to violate the Federal Trade Commission Act. And the interesting thing is, Congress has looked at that issue. Back in 2019, November of 2019, Congress held hearings on whether or not non-compete agreements were valid. And it was over a proposed amendment to the Fair Labor Standards Act as to whether or not they should continue to be allowed. So clearly, Congress has had the ability and the interest in regulating in this area, but they did not delegate that authority to the Federal Trade Commission. So people who have these non-competes, you may be able to escape them under this rule, and the rule itself may be challenged in court, and you may wind up not being able to get out of your non-competes. So, as a practical matter, it is a good idea to keep a close watch on this if you think you want to get out of your non-compete agreement, because this rule may not actually stand over the long haul, and how it will affect your particular situation if your local court refuses to enforce the agreement because of this rule, and then that rule is later overturned by the appellate courts or by the Supreme Court itself. Well, then you may have a real problem. So again, a good idea to proceed with caution and perhaps negotiate with your current employer about this particular issue. So that's what I have for you today. Thank you very much for watching. If you have any questions, drop them in the comments down below. Like, share, subscribe, you know all that stuff we ask you to do. And if you have the opportunity today, do something nice for somebody. Go out of your way, open a door. Just be kind to people. It's a great way to make your day better. After you do that, come on back here tomorrow, join us down here at the beach, and we'll have fun talking about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.